Hello, and welcome to One-on-One with Robert Doar. I'm your host, Robert Doar, and thanks for tuning in today. As president of the American Enterprise Institute, I have the unique privilege of working with America's greatest policy experts. These scholars focus on policy issues in the fields of education, economics, energy, foreign and defense, and so much more. Subscribe to this podcast for exclusive access to in-depth discussions on the most pressing policy issues. Together, with my guests, we'll challenge political preconceptions, explore innovative ideas, and create, I hope, a freer and safer world. So today, we have a rare treat in that we have Adam White in the wake of a really remarkable term for the Supreme Court. Adam White is our constitutional law scholar. He's the Silberman Chair. We're very pleased about that, and is, I think, and I think everyone at AEI thinks, and people outside of AEI think, is the smartest constitutional scholar not on the court in the United States. So Adam, great to have you. Thanks for being here. Over the course of we're going to do 2 sessions with Adam. We're going to cover 4 cases at least. And so today we're going to talk about the Chevron, the overruling of Chevron, and then the immunity case, the Trump versus the United States case. And so and what I think about these cases, and a lot of the cases this term, and Adam, tell me if I'm right, is there's kind of a celebration or an education in the separation of powers and the proper role of the 3 branches. It seems to me that the judges, the court members were doing a lot of discussion of who does what and why. Now, whereas in other terms, the court may have been focusing on the rights of individuals and free speech, this time they were focusing on the proper role of judges in our constitutional system, the role of Congress, and also of the executive branch. And we're going to start first to talk about the Article 2 branch in a minute. But first, let's turn to Loper Bright Enterprises versus Raimondo. In the past, Adam, under the Chevron decision that Justice Scalia wrote, I think, is that right?
He didn't write it, but he was its biggest. He joined the court right after it, and he was its biggest advocate for a long time.
And the theory of that position was that when the statute was ambiguous, the courts would defer to the agency expertise in deciding what to do and what was the law and what they were allowed to do. That there might be multiple interpretations of the statute. But because the agency in charge of the implementing of that statute had certain expertise and knowledge, courts were directed to defer to their judgment. Is that correct?
Yeah, it was about expertise, but also about democracy, the idea that judges are not elected policymakers. And so after each presidential election, a new administration might reinterpret a vague statute. And, of course, the court pointed out most statutes have some vagueness in them.
And now, in the decision that Justice Roberts wrote, if the court's interpretation is better, then it is impermissible to defer to the agency in charge.
Yeah.
And so it's a real shift.
It is. I saw one journalist in Barron's magazine, one law professor, call it an earthquake. I'd say it's not quite an earthquake, it's more a vibe shift, but it is an important vibe shift. You can see how the court is really taking on a different sensibility in what it means to interpret these vague statutes.
So it's a loss for executive branch administrative agencies.
Yeah, it is. And isn't that funny that the other case we're going to talk about is taken as a big gain for the executive branch?
Yes, but sticking with this one for a minute, it's a loss for the executive branch agencies and the presidents, because one of the things you write about in a great piece in the Dispatch is that under the previous regime, prior to this decision, agencies' interpretations of statutes could shift from one president to the next or one party in power to the next, and that created some instability. And the courts were sort of stuck with this previous decision that said, no, you must defer. That's over now.
That's basically over now.
So it's a loss for their ability to decide things, but it's a win. It could be a win or a charge to redirect the political energy to where it belongs. Is one of the words in the court's decision. Congress. What about that?
That's right, and that's been a big theme that we've seen in the writings from our colleagues Phil Wallach and Yuval Levin. Both of them have seen that one of the problems with Chevron deference, and by the way, Chevron had some virtues. I mean, Scalia was for it, and he was no fool. But one of the real challenges was that Chevron deference redirected almost all of our political energy away, in terms of policymaking, away from Congress and towards the agencies. You don't like the law, you go to where the law is really made, agencies, and get it changed. Well, Congress said, or the court said, no. Congress makes the laws. We interpret the laws. Sure, there might be a little bit of wiggle room for agencies, and we'll take that seriously, but we'll interpret the law. And if you don't like our interpretation, go back to Congress and get them to change the actual law.
So I'm glad you mentioned that, because some people, Alexander Bickel, I think you had the phrase least dangerous branch. And the theory was the courts should not assert too much power in our constitutional system and defer to the political branches. A lot of the critics of this decision say this is a power grab by the courts. How do you respond to that?
Well, it certainly does. It shows the court asserting itself more. And you're right that Bickel famously counseled for judicial restraint. And in fact, that's why Scalia and others of that generation, of Scalia's generation, liked Chevron. They were worried that the greatest problem in constitutional politics at that time was judicial overreach. Scalia said around this time Chevron was decided, he said in an article, every generation has its own challenge to the constitutional order, and ours, he said, is judicial ambition. So now the argument would be the pendulum has swung actually too far. Courts were being too restrained. They weren't living up to their responsibility to actually say what the law is. And now we'll see if things settle back in the right place, or if we overcorrect in the other direction back towards judicial authority.
Now, at the very end of your piece in the Dispatch, you bring up an issue that's been on my mind as I've thought about this.
Yeah.
And that is appropriate delegation of working out the specifics. A Congress, a state legislature, or a legislature can't understand all the complexities of every issue. Yeah. And there could be language. I mean, I'm a former executive branch appointee. There could be language that says this is basically what we want, but in working out the details, how do you get there? We delegate to the executive branch agency to determine the minutiae and the specifics. Yeah. What about that? Is that still permissible?
Yeah, that's the preview of coming attractions. This was the most interesting paragraph in the whole opinion for all the real administrative law nerds. Just the basic point for those listeners who haven't read this paragraph yet. The court says, of course, there are going to be cases where Congress delegates some kind of policymaking discretion to agencies, and we, the courts, will review that in certain ways under the Administrative Procedure Act. But when the court used the word delegations, they said constitutional delegations. And that's a way to kind of paper over an important, subtle, I wouldn't say disagreement, maybe difference of opinions of where the conservative justices are right now on whether the court should just strike down statutes as unconstitutional when they delegate arguably legislative power to an agency. I think that will be the next big fight in administrative law. I think in some ways Loper-Bright will accelerate those debates because judges are going to spend all this time staring at statutes trying to get the best meaning and then throwing up their hands saying there's no there. It must be an unconstitutional just delegation of lawmaking power to the agency. And so that's what I'm looking for next.
But you don't disagree that it's hard to define all the details of a particular legislative initiative and how it will work out when it's being implemented. And there are some things Congress just can't figure out in advance, or not. Or do you disagree with that? Do you think Congress should be that specific into the minutiae of every little detail of an agency's practice?
They can try. And that's why what Phil and Kevin Kosar have been writing here about congressional capacity is so important. It's been so long since Congress has really built up expertise in its own institution rather than outsourcing that to agencies. So Congress could do more. Now, that said, there's no such thing as a perfect statute. Madison wrote about this in my favorite Federalist paper, Federalist 37. He said all laws, no matter how hard Congress tries, or a legislature tries to write them carefully and precisely, there's always going to be a little bit of vagueness left in them. And that is what, in a way, Chevron was trying to grapple with. Now, I would say Congress could do a better job than it's currently doing, but I tell my conservative and libertarian friends, let's not expect perfection from Congress, and let's be careful about the courts going too far in imposing meaning on statutes that really are indeterminate.
Well, it's not just vagueness, Adam. It's also details, specifics that is just hard to anticipate in advance when you're drafting a statute. And administrative agencies, I do think you're right. The conservative members do seem to be divided on that, where some are recognizing some things are appropriately delegated to the agencies to work out, and other things might not be, or where that line is.
My guess is none of the 5 justices in the majority of Loper Bright would say that it's constitutional for Congress to delegate lawmaking power to agencies, but then they might disagree subtly over what that actually means and what counts as a delegation of lawmaking authority.
Okay, I get that, but I'm as a former implementer of statutes, not everything's in the statute, and how to write the document that communicates the meaning of the statute, how to set the sometimes even penalties or if someone violates in an administrative practice. Now, you also threw in, I just want to be sure I understand that, you're subject to the Administrative Practice Act. Yeah. Isn't that a little bit of a protector there? What does that do in this conversation?
That creates all kinds of procedures that agencies are supposed to follow when they're making rules, when they're adjudicating cases. It also has standards of review for the courts to follow when they're reviewing the agency's legal interpretations or factual findings or policy-making justifications.
All of which anticipates that a statute can't define everything.
Well, yeah, the APA was written in 1946, and it really embodies Congress's zeitgeist at that time, that Congress had just delegated enormous powers to the Roosevelt and then Truman administrations, and now they're imposing procedural regularity on it so that courts could be better overseers of this new administrative state.
At the end of your piece in the Dispatch, I think you try to turn a phrase that Justice Kagan uses in her dissent against her. Yeah. Could you explain to me what you're trying to do there?
Yeah, at oral argument, Kagan, in defense of Chevron deference, kept pushing the lawyers.
You're referring to Justice Kagan?
Yes, Justice Kagan. My former Dean Kagan at the law school. Justice Kagan kept pushing lawyers to admit that sometimes it's just impossible for judges to neutrally and in a principled way find the best meaning of a statute. There's no there. The kind of statutes you're talking about where it really is just a delegation of power to agencies.
Right. The meaning is just they just haven't covered it, or it's not all there.
Yeah. And she said sometimes...
It's not that it's empty. It's that it didn't get all the way to every detail.
Right. And she says sometimes the law just runs out. Sometimes the legal toolkit judges use to try to find meaning in a statute just can't actually find the meaning. Sometimes the law just runs out. And as I said at the end of the piece, that's a good rallying cry for a pro-Chevron argument. It's also a good rallying cry for a pro-non-delegation argument. The conservative judges, justices might look at a statute, try everything they can to pull the meaning out of it and finally say the law just runs out. And to Justice Gorsuch, Justice Thomas, that's a pretty good mantra for a non-delegation doctrine. Yeah. Can I throw one more thing?
Yes,
in?
Yes.
What I thought was very interesting about this opinion, I think it really is evocative of Chief Justice Roberts. Over the years, including in cases during the Trump administration where he wrote opinions against the Trump administration, he's clearly worried about the flip-flop problem, about each new administration totally changing policies. That's why every presidential election now feels kind of like the everything election. Mm-hmm. All the policies are up for grabs. Chief Justice Roberts has, in many different ways over his 20 years on the court, nearly 20 years, has criticized this, joked about it, pushed back against it. And as I've pointed out in a few writings over the years, and I'll be doing more soon, he's really, without really quoting a lot of these materials, he's gravitating towards a lot of the themes in the Federalist about the need for steady administration. Alexander Hamilton's worst nightmare in the Federalist was each new administration coming in and just making the world anew, throwing out everything that had been done before. It's no way to run a country. It's the kind of country that nobody can really plan their lives around. And in this case and in other cases, Roberts, in these Chief Justice Roberts' opinions, is trying to make administration steadier. And the line actually does come up at the outset of the Loper Bright case. He quotes Federalist 78 on the point. But I think this is going to be a continued theme going forward.
Well, that's very nice, Adam. We like steady. We like reliable. I think there's a whole jurisprudence on the being able to rely on the law.
Yep, exactly.
But you're a litigator, and you're active in the bar, or you have been in the past. Isn't this also going to result in a lot of litigation that might lead to a lack of steadiness?
Yeah, it will, and I'm glad you brought that up. There was another case that was decided at the end of the term, a smaller case about financial regulation called Corner Post, which extended out really the time frame in which new companies can sue over old regulations. And that decision, combined with this decision, has a lot of people worrying that now there's going to be all sorts of new litigation, challenging old rules, challenging new rules under old legal interpretations. That's true. There's another kind of...
just to interrupt me, that kind of litigation, is my understanding, I could be completely wrong, but sometimes it's centered around, because of Chevron deference, around and failing to apply the rules of the Administrative Practices Act in setting the standards. So you have to get them on process.
Well, but you can also, yes, or on the meaning of the legal interpretations.
Right, but now you can get them, you have a bigger opening to get them on the meaning of their legal determinations, because if the court had ruled to defer to them, now they're going to reopen those, and that will lead to more litigation.
It will. And the other way it'll create unsteadiness is you'll have different courts disagreeing over what's the best meaning of a given statute in time. So you're going to get some uncertainty there. But can I give you the other side of the ledger here? And this is what I emphasize in
your article.
The piece, is that ending Chevron deference creates that kind of uncertainty. But it also ends the uncertainty of these wild swings in policy from one administration to the next. And that has been much more crippling than any kind of short-term uncertainty we'll have over an initial flurry of lawsuits, which in the end will settle the meaning of these statutes. And then like short-term disagreements among courts before the Supreme Court gets to resolve a statutory dispute. There will be new kinds of uncertainty, but the Roberts Court is clearly here worried about the long-term certainty, not the short-term stuff.
Yes, I thought you handled that well in your piece, where you said that there is going to be that, no question about it, but it will get worked out, and it'll get worked out in a way that will make it more solid than this flip-flop between one administration to the next. And just to be clear, how do you respond to the argument that says the flip-flop from one administration to the next allows the people to have a say? Elections have consequences, Adam. Is this a little bit undemocratic?
Well, yeah, no, it's to agree with it. That was one of Scalia's main arguments for this, that elections should have consequences. There should be room for change from one administration to the next. Change is a good thing, but you can have too much of a good thing. We just went too far in the other direction. If at the end of the day, Chevron and now Loper-Bright are about how we interpret statutes, well, we create laws democratically, but we don't interpret them democratically.
And also, the politics of Congress becomes a role. I mean, Congress have been sort of left out of this entire thing. Now those elections will have more consequences. Congress will write statutes with either greater clarity or go into details that they were trying to avoid and defer to someone else.
That's the hope.
Yep. Okay. So now we turn to the big one, and as the more I reread it again today, and it really is a big decision. This may be the wrong way to run this podcast, but I'm going to try to tell you what I read in it, and then you're going to tell me how to define these terms.
All right.
So Justice Roberts, and this really may be the most important decision of his career as a Supreme Court judge. It's very possible, although he's done a lot of big ones.
Yeah.
And it's new terrain.
Yep.
This is not something the court has tackled with before. A criminal prosecution against the president has never happened before.
Yeah, we had a pretty good run there.
There's only really two cases that he could rely on: the Fitzgerald case and the Nixon tapes case.
Yep.
But he said that presidents are immune from prosecution, criminal prosecution, for official actions that fall within their core responsibilities.
Yep.
They're presumptively immune, which means that they're not entirely immune. An argument can be made that they should be liable for prosecution, but there's a sort of starting point deference to them being protected from official actions that are not in their core responsibilities, but it's pretty broad.
Yep.
And then all unofficial actions, or another way of calling them private actions, they're not immune at all.
Yeah.
Is that right?
Yeah.
Okay. So let's go to the official actions. They're the easy ones.
Yeah.
The pardon power.
Yes.
That what he's trying to say is you can't prosecute the president for exercising his power of pardoning.
That's right. And some other examples would be his communications with or his directives to his senior cabinet officials and others. Probably his power to be commander-in-chief of the military, surely.
Well, you're right, and I wanted to know, when you're looking for those official powers, is a good place to look Article 2 of the Constitution?
Yeah, you look at Article 2, but it's not that everything's always going to be written in stone. We've got an entire now 2 centuries of a building out of presidential norms and traditions. So, for example, here's where I'm going with this. Article 1 of the Constitution gives Congress the power to declare war. It gives the president power to be commander-in-chief. In between there, it doesn't say necessarily that a president has the power to put troops into action to defend somebody else taking war to us. But it's pretty implicit from the Constitution, as our colleagues John Yoo and Jack Goldsmith and Gary Schmidt would say. And I'd say that even if that power isn't spelled out in the Constitution, it's in there.
Okay, well, the Roberts opinion is full of references to the Federalist Papers and references to Justice Jackson's opinion in the Steele case and references to traditions and norms and practices.
Yeah.
Not so much on specific references to constitutional language. You've
That's
got
right.
to admit that.
Oh, yeah.
And the dissent makes that point quite strongly.
Yeah.
And
I got some
am
thoughts
I
about that,
wrong
too,
to
actually.
think what?
I have some thoughts about that, too.
And am I wrong to think that some of that language about traditions and norms and practices sounds a little like the Warren Court's citation of extra constitutional mandates?
Yeah, courts have to be careful with how far they go with this. But let me just say, since you mentioned the dissent, I know the dissent said, there's no executive immunity clause in the Constitution.
Yeah,
that's true. There's no congressional subpoena power in the Constitution either. And by the way, there's no judicial review provision in Article 3 of the Constitution that says we the courts are, in the end, in charge of interpreting the laws. All 3 of those things have long been understood to be necessary adjuncts to each branch's explicitly enumerated powers.
Okay, but the justification for all of this, in the Roberts' opinion, is that the founders and America wants a strong president.
Strong, swift,
vigorous,
steady.
And I'm just curious, in the world of conservatives, where did this love of a powerful president come from? Because in all other contexts, we like to limit power, don't we?
Oh, sure. Well, like a lot of modern conservative ideas, we got them from FDR. I mean, it is like an interesting echo that the coming out of the Nixon administration and what was seen, no offense to the Doors family members in the room, as an assault on presidential power. Created an effort to really recognize the president's unitary role atop the executive branch and the need to push back against efforts by Congress or the courts to hobble the energetic, swift, steady administration of the laws.
Well, as a small government conservative, I'm a little nervous about too much power in any one place. And I think you are too, Adam. Come on.
Well, I absolutely am. And again, that's why I didn't like I was uncomfortable with how much policy-making power Chevron deference gave to presidents.
Yeah, there you go. Okay.
Can I just
let's just go to the official actions that are related to the core powers of the presidency. I grant you that those are appointments to the cabinet.
Yep.
Conversations with the attorney general.
Yep.
That's fairly easy, and I get that. The whole business. I mean, by the way, there's a long history of fighting over the presidential appointment power. I think President Johnson, Andrew Johnson's impeachment was over that, and that was resolved in the president's favor. So I'm okay with that. But let's take these official actions that are non-core, and let's take some things from the past.
Yeah, this is the quiz portion of the conversation.
Okay, so let's talk about a president who suborns perjury or encourages perjury in a criminal prosecution.
Yeah. So, and I'm just warning you up front, listeners, I'm not going to be able to answer his questions, but I'm going to tell you how to think about them.
Okay.
The question here is, in what role is he doing it? What's the function? The court says we're not going to worry about the person, who the president is. We're not going to worry about motives. We're going to worry about the function. So if the president was talking to, say, his attorney general who is testifying in a case, or his treasury secretary or something, it's true, he might not be able to be prosecuted for allegedly suborning perjury. But if it's a case involving like a private business or something, unofficial act.
Okay, well, let's talk about communicating to one federal agency the desire that they tell another investigatory agency, the Justice Department, that something going on has got a national security background when it really doesn't.
Yeah.
What about that? What about, this was really the big element in the Watergate obstruction of justice charge against President Nixon, which was, and we're going to talk about impeachment in a minute.
Yeah.
It never did get to the courts. But I think what he was accused of doing and what he did was he said, tell the CIA to tell the Justice Department that the guys who broke into the Democratic National Committee headquarters were on a national security, they were doing CIA work. And it wasn't true.
Yeah.
Now that's communicating with your team.
Yeah.
And it's purported to be for an official purpose, but what is a judge to do with that?
I think that probably fits into the court's framework for what would be immune. Justice Scalia used to have a line. He'd say, "Sometimes I wish I had a stamp on my desk where I could just stamp things, stupid but constitutional." This one would be a stamp. This stamp would say, "Awful but constitutional." But yeah, I think it fits into the court's framework for immunity.
Asking the IRS to harass political opponents?
Probably immunity.
Man, oh.
Can I offer a word in defense
again,
of all this?
I don't know if I can. I don't know how comfortable I am with that.
Well, I'm not comfortable with it either, by the way. In terms of the scenarios we're painting out here, and what the court is clearly worried about is not just these scenarios where, in the hypothetical, we can say with absolute certainty that the president has done something that's not just bad but also illegal and ought to be prosecuted. What the court's also worried about, and they really emphasize this towards the end of the opinion, is that that's not all cases. Lots of lawsuits can be brought alleging things that are clearly not true. Lawsuits can be brought in good faith, challenging things at the margin, where it's an open question whether what the president did was right or wrong, legal or illegal. And the litigation around that can bog down a presidency. So the court is making very clear, in a way very similar to Justice Scalia's dissent in Morrison versus Olson, the famous case over the independent counsel statute, where Scalia himself there said, giving the president this much constitutional power over execution obviously leaves the door open to abuses. But it's all the other problems on the other side of the scale that we have to guard against here.
Okay, and I respect that, and Doar family members have been prominent members of the president's team too, and want to protect the president's powers. So I'm all for that. But let's part of the problem with this is the kind of rhetoric that I'm using in this questioning is a little bit, not entirely fair, because there's an implication that it mean that the Chief Justice Roberts was saying that anything the president does is legal,
right,
when the case he cites, right off the top, is the case against President Truman for exceeding his authority in the Steele seizure case. Isn't that correct?
Yeah, that's right. A lot of the staff around here are too young to remember this, but Robert, you'll remember this, and I'll remember this, that when Chief Justice Roberts was nominated in 2004, that was the case everybody was talking about. In the aftermath of the 9/11 attacks, and the invasion of Iraq, everybody was talking about the Steele seizure opinion, Justice Jackson's sort of three-part framework for understanding what powers belong to the president, which ones belong to Congress, and which ones are kind of in the middle. And so it's interesting that now here we are 20 years later, and Chief Justice Roberts is taking basically the Jackson framework that everybody talked about back then and applying something very similar to it in this context of presidential power, presidential immunity, and the power of the courts to adjudicate those cases.
Yes, but that last point is the point I'm trying to make, is that Justice Jackson ruled that President Truman had done something that was unconstitutional.
Yeah.
So just because you have immunity from criminal prosecution post-election doesn't mean the court is saying the president can do anything.
Right.
And there will come a time when this court or any court could say to a president, future president, leaving aside criminal prosecution, you don't have that power.
Yeah, absolutely. And since we blew through the examples really quickly, I just want to point out that there are going to be some cases where presidential power, even an official act, is still going to be not immune to. It's going to be not immune to criminal investigation or prosecution because in this opinion, the majority says the trial courts will have to decide how burdensome would this investigation be into the operations of the executive. So I don't want to blow past that either.
Right.
But
It's
you're
important
right.
to remind our listeners that the Justice Roberts, for a lot of it, said, look, we can't, I mean, how many times does he quote, we are the final word, not the first word.
Right.
And are you a big believer in, do you like his use of that to say, look, I don't want to decide this. I want to send this back to the trial courts?
Yeah, and I think he was right. And I counted at least 3 times in the majority opinion where the majority really kicks the district court a little bit for blowing through this all so quickly without any real kind of factual findings or anything. Here's what Chief Justice Roberts did, and I haven't pointed this out, and nobody else has yet either, so we're breaking news here on the one-on-one podcast. What Roberts did here is he sketched a big framework, said here are basically the easier cases. We know this category. We know this category. There's going to be some hard cases in the middle that are mostly factual questions, but here's the basic framework. That's exactly what he did a couple of terms ago in a case involving Congress's subpoena power over the executive branch. The court said, yeah, Congress has this subpoena power. I don't remember Justice Sotomayor saying, there's no subpoena power provision in the Constitution, but we'll get past that. They said, here's the basic framework, but of course Congress's power isn't totally unlimited. It has to have a proper legislative purpose, and the courts can kind of police to make sure this isn't too burdensome. Same thing, one more example for you. Same thing in the Moore versus Harper case, I think a year ago, independent state legislatures. Who has power over district lines? The state legislatures, state courts. The Supreme Court says actually the state courts do have real power here interpreting the state laws, state constitutions. So here's the framework. But they said if the courts go overboard, the federal courts will be there to police that. So in all 3 of those examples, the Roberts Court, all 3 Roberts opinions, by the way, he sketches out this big separation of powers framework, but then accepts that there's going to be hard cases. Those cases will be hard because they'll be factual bound, but you can't let hard cases make the law because hard cases make bad law.
Okay, so one thing that's left out of there are 2 other elements of the opinion that where I wanted to ask you about. One is the take care clause.
Yeah.
That is in Article 2.
Yes.
Roberts doesn't put a lot of stock in that, or does he? Take care that the laws be faithfully executed.
Yeah, I've read it. Well, I was going to say, you're right that he doesn't put a whole lot explicitly on it, but in some ways, the opinion as a whole is a reflection of that. The fact that all presidents have this obligation, even if it's not enforceable by the courts, that it's up to the American people to understand that when you pick a president, you have to pick someone who's actually going to take care that the laws are faithfully executed.
Okay, so that gets me to the last thing. He doesn't. Well, before we do that, I just want to mention one thing. He cites Nixon versus the United States, Jaworski versus Nixon, or
Nixon versus United States.
Nixon versus the United States in the tapes case.
Yeah.
And he cites it approvingly. He does not contradict it, and he says there are. But what he says is the court there ruled that the tapes needed to be handed over.
Yep.
But they also said that was overriding a presumption that he deserved some protection for conversations between aides.
Yeah.
But I guess what's left out is that there was enough in the record to make the court feel comfortable in that case.
Yes.
To release those tapes, I think even under some requirements.
Yes, and that's how sort of Category 2 in this new Trump versus United States framework will work out.
Right. So in other words, in the Roberts world, something can happen which grants a lot of immunity and a lot of protections to the president.
Yeah.
The Nixon tapes case still stands strong.
Yeah.
Okay. So now we come to the one word he uses. It's in it. It's in the. I think there's one reference to it. But what about impeachment?
Yeah.
What is Roberts' attitude toward impeachment with regard to presidential malfeasance?
Well, I mean, he brings it up. I think it's more, the message is more implicit than explicit. It's that not every violation of the Constitution is to be adjudicated by federal trial courts. In this case, because the president has the executive power, the constitutional mechanism for policing this is impeachment.
There you go, Adam. There you go.
There you go.
The president should be challenged in this context for doing things only presidents can do and doing them in a way that violates the high crimes and misdemeanor prohibition.
Yeah, and I remember just a few years ago, an AEI scholar wrote a great piece for National Review saying that the Senate really needs to take this much more seriously, invest itself much more in overseeing administration, and be ready to use that impeachment power. It was me.
Yeah. Okay. So, all right. Well,
I have to drag the Chevron case back in. I said at the beginning, how is it that just days apart in two of the biggest cases of the year, the Roberts Court issues one decision that really disempowers presidents, the Chevron deference case, and then another case where it really empowers presidents, the Trump v. United States. This is a very, AEI, Yuval Levinian point, I suppose, but it comes down to what's the actual job of an institution in government. The executive branch's job is not to be our policymaker in chief. The president has a lot of policy, has a big role in the legislative process, and an administration is inevitably going to have a lot of discretion, whether intentionally or unintentionally. But the institution is not built for that. It's not built to be a policymaking body. And Chevron has tightened up the president's policymaking discretion, but in a way that's consistent with the institution. This analysis of the executive branch in Trump versus United States is a ground-up analysis of what is the executive branch built to do, and what does it need in order to do that job correctly. And its fundamental job, as described in Federalist 70, is to be an energetic executive for the swift and steady administration of the laws and the protection of national defense. And so the court is empowering the executive branch to do that.
Well, I'd love to get our historians who are experts in the founders, because you guys are relying an awful lot on a couple phrases from the Federalist Papers.
Yeah,
and it seemed to me, and in the dissent, it's more there. You're ignoring a whole lot of other language by founders.
Yeah.
You remember what the revolution was really about? Excessive power by the king.
Yeah.
I mean, they were very nervous about a president.
Yeah, they were.
That was too powerful. And I found this dialogue we had before where you said it all began with Roosevelt not reassuring.
I was teasing. but I'll tell you, Robert, when you go back, as I know you often do, and read the Declaration of Independence, of all of the complaints about the king, maybe half of them were complaints about the king's overreach. The other half, amazingly, were complaints about the king's underreach. The fact that he didn't allow laws to be made or administered. The framers, especially when you get to 1787, they are as worried about a lack of administration as much as they are an overabundance of administration.
But, okay, so just last question on this. What are we going to do when we have a situation where the court rules that the executive branch's use of a statute through its administrative agencies is wrong and outside of what the law, and the president and his people refuse to comply?
Yeah. Well, it's a good question. It's something else that Hamilton alluded to in Federalist 78. Sometimes he said this is just going to happen. There isn't a good answer to this, honestly, and we're lucky that we have sort of a norm that avoids this. But actually what I think is more likely to happen in the aftermath of the Chevron decision especially is that more and more policymaking will be made kind of underground. I keep trying to use the term passive-aggressive administration, ways in which agencies can make policy, can change day-to-day activity in the world without doing it through a rule or an official, adjudication or something. I think we'll see a lot more of that, and that's going to be harder for the courts to police. Now, but to bring it back to Trump versus the United States, what happens if a president just goes totally rogue? Well, there is a lot of room in the Roberts Court framework here for a lot of things to be prosecuted. Most of the scenarios that will come to happen in the real world will fit into that middle category. Official, but still not necessarily immune. But this opinion is a challenge to Congress and American voters to do their own roles.
Yes, I think that's what the point you should make, is that for policing presidential misconduct, the power to do it right resides in Congress and the people.
Yeah.
And the idea that, U.S. attorneys' offices across the country are going to investigate the president and prosecute him or threaten to prosecute him for criminal actions is a silly way to run a country. And I think that's really what Justice Roberts is trying to say. This isn't the place to work this out.
Yeah.
Is that fair?
Yeah.
Okay.
It's about steady administration. Trademark.
And limited powers
Yeah.
of various branches of government.
That's right.
Okay.
Not just that the powers are limited, but each power is different, and it is where it belongs.
Okay, with that, we're going to stop. We're going to come back in a couple days and do 2 more cases and also talk about Justice Roberts and his role as a Chief Justice.
Terrific.
Thank you. See you next time.